Welcome to this course on copyright and related rights law. This week, we are looking to understand the requirement of originality, which is a foundational requirement for considering determination of whether copyright can subsist in a work or not. In the previous session, we have discussed how courts have used the doctrine of sweat of brow in order to make such a determination. Their application seemed to extend copyright protection beyond what copyright protection is supposed to cater to. In response to such an extension, which was particularly seen in the case of compilation, the US Supreme Court in Feist versus Rural provided that an expression would have to satisfy a minimal level of creativity if it had to be granted copyright protection. What is then our understanding of the Feist decision? The focus on effort or the focus on labor towards the determination of subsistence of copyright would not by itself be enough to determine subsistence of copyright. There would have to be something additional. That something additional, according to the US Supreme Court, is a minimal level of creativity. In saying so, the US Supreme Court had clearly explained that a minimal level of creativity doesn't encompass a level of inventive thought or a level of novelty or non-obviousness that we see in patent law with relation to inventions. What we will look at in this session is two important judgments, both from the apex courts in their country. The first case that we are going to look at was decided by the Canadian Supreme Court. The case is CCH Canadian versus Law Society of Upper Canada. In this case, the question of originality and how it must be considered was brought to the attention of the court because of the varied nature of its application among courts in Canada, where some courts were applying the doctrine of sweat of brow and applying it in a way that labor and the expenditure of labor would be a sole consideration for determination of copyright. Whereas some other courts were of the opinion that something else apart from an expenditure of labor in the form of creativity was required. How is this conflicting opinion matching in terms of what we had understood in Feist? Keep that in mind as we go forward in our discussion of this particular case. In constructing originality, the Canadian Supreme Court also saw the kind of problems that would arise if labor was the focus of the judge who was looking to identify whether copyright was subsisting in a given expression or not. Therefore, in the Canadian Supreme Court's understanding, it would be better if labor as a consideration in any such test was possibly dropped and the focus rather shifted to the use of the terms skill and judgment. Once we focus on these terms, then as we had understood, the consideration of judgment necessarily brings with it a question of application of mind. Or in other words, is there any difference in the manner in which such a expression has been made? Has there been any variation? Now, in terms of what this variation should be, or what this different nature of expression should be, it needn't satisfy the level of novelty or non-obviousness, which is what the court is explaining. The exercise of skill and judgment required to produce the work must not be so trivial that it could be characterized as a purely mechanical exercise. What the court explains is that if we consider the level of skill and judgment that must be satisfied, it is a low threshold. Isn't this similar to what we were discussing in Feist versus Rural? But unlike Feist versus Rural, where the US Supreme Court was emphasizing on a minimal degree of creativity being satisfied, the Canadian Supreme Court felt that the use of the word creative can in fact cause confusion. Why is this the case? We understand that creativity is used in terms of inventive capacity to generate something new. And therefore, when we say that a person has created something, it is a confusing stance sometimes because we think that we are referring to a new creation, something that hasn't existed, or even if something has existed, there has been an improvement to it of such a nature that it wasn't obvious to others. Thus, according to the court, a reference to skill and judgment was a sufficient consideration. As you can see, the court was saying, creative works by definition are original and are protected by copyright, but creativity is not required in order to render a work original. The original work should be the product of an exercise of skill and judgment, and it is a workable yet fair standard. The sweat of the brow approach to originality is too low a standard. On the other hand, the creativity standard of originality is too high. The creative standard implies that something must be novel or non-obvious, concepts more properly associated with patent law than copyright law. At this stage itself, we can make a distinction between how the Feist court, the US Supreme Court, was approaching originality and how the Canadian Supreme Court is approaching originality. The difference seems to be in the usage or non-usage of the term creative. Creative being used by the US Supreme Court, being referred to as an additional requirement, but something that doesn't extend to novelty. And creativity as a term that should not be used, according to the Canadian Supreme Court, is because it can lead to a confusion with relation to a high standard, a standard of novelty or non-obviousness. Therefore, we see that although the manner of approach of the US Supreme Court and the Canadian Supreme Court is different, in essence, they seem to be suggesting the same effect. Therefore, when the Canadian Supreme Court says that only skill and judgment must be considered, we can say that if we were to say that minimal degree of creativity is required over labor, then a skill and judgment standard is proposing a similar effect. As you can see, what the Canadian Supreme Court says is, by way of contrast, a standard requiring the exercise of skill and judgment in the production of a work avoids these difficulties and provides a workable and appropriate standard. To quickly recap, what the Canadian Supreme Court is seeing as difficulties is: one, the application of labor. How is that a difficulty? Focus on labor can lead to application of the test for determination of copyright in such a way where copyright can extend to subject matters which are not protectable, such as facts. And second difficulty is that of reference to the word creativity, because creation can be referred in terms of novelty. I'm sure now, when you consider how the Canadian Supreme Court decision is different from Feist or not different from Feist, you have a clearer understanding of where these courts are taking originality. With that in mind, let us now discuss a very important case decided by the Indian Supreme Court. This is Eastern Book Company versus D.V. Modi. Eastern Book Company is a company which is involved in the business of printing and publishing. A publication, a famous publication, which is run by them, is called Supreme Court Cases. We will refer to it as SEC. How SEC functions is that SEC takes judgments which have been pronounced by the court, over which then the staff of SEC would make certain modifications or certain input additions in such a way that the judgment itself is made more user-friendly. Now, there are two things that we must understand very clearly. One is that judgments, because they are made in the cause of public interest, they are free to use. Second, in delivering a judgment, in authoring that judgment, the judge makes many references to judgments, to provisions, and these are also stated in paragraph forms, and there is a connection between the expressive effort that is carried out by the judge in the judgment. And therefore, where the purpose of the judgment is to enable the user to understand how the law has been applied to a particular fact, must be clear to the user. Therefore, the expressive format in a particular judgment is in any case meant for being read by a user. What then inputs can do in terms of editing the judgment and including certain modifications is to go beyond the already existing user-friendly nature and make it more user-friendly. And to do it, it would have to bring in a certain kind of creative effort, which is where the question revolves around originality in this particular judgment. The Indian Supreme Court's application of originality and its construction is very helpful in terms of relating it to how originality has evolved in both US and in Canada, and as well as in the UK, and also for us as people who are looking to understand originality. Two sets of examples where one is not creative and another was held to be creative by the court. The question then revolved around copy editing and some of the inputs that were made by the staff at SEC, and whether these inputs and whether such formatting could be considered as original or not. Like I said, the purpose here is to make it more user-friendly. Why does a judgment need to be made user-friendly? Because judgments are meant to be read by users, and these users are members of the public. Members of the public are not well versed in technicalities of law, and therefore, if certain inputs can be provided in such a way so as to make it more accessible to a wider range of public, then such an input can in fact go a long way in assisting a user in appreciating a judgment. Another aspect that must be considered is that judgments can be very lengthy depending on the substantive question which the court is looking to answer. The complexity of the reasoning could be such that it stretches to many, many pages, and therefore any kind of assistance in terms of an arrangement or any modifications or inputs that are made can in fact be considered as original. But in terms of whether all of these modifications or inputs are original, the court is making a reference to how originality has evolved. So firstly, let us contextualize this on the basis of what modification is the court pointing to. The first type of modification that the court is pointing to is the kind of formatting or arrangement that has been done by SEC, which according to them fits their style of arrangement. Now, according to the court, such kinds of arrangement, which by itself doesn't demonstrate any kind of a judgment application or an application of mind, which is very trivial in its nature and something that can be considered commonplace in terms of its effort or the skill required. The court referred to and stated in terms of skill and judgment that the exercise of skill and judgment required to produce the work is trivial and is on account of the labor and the capital invested and could be characterized as purely a work which has been brought about by putting some amount of labor by the appellants. What do we see here? We see that the court, in using skill and judgment as a criterion for determining originality, has taken the inspiration from the Canadian Supreme Court. CCH Canada also refers to skill and judgment and drops labor as a focal point in the determination of copyright subsistence. which is what the Indian Supreme Court also is stating. If you can see in the first paragraph on the slide, the last line, the court is saying that does not give the flavor of minimum requirement of creativity. Isn't the Indian Supreme Court also inspired from the usage of such a requirement by the US Supreme Court? As you can see, what the court is saying is, although for establishing a copyright, the creativity standard applied is not that something must be novel or non-obvious, but some amount of creativity in the work to claim a copyright is required. Therefore, it does require a minimal degree of creativity. When we consider the use of skill and judgment and minimal degree of creativity together, we are seeing that the Indian Supreme Court has considered in very clear terms and in very expansive nature of consideration of the evolution of originality, the doctrine of sweater brow and its application by courts, the construction of originality by the US Supreme Court, the construction by the Canadian Supreme Court, and eventually what the Indian Supreme Court states is that skill and judgment is the test which must be considered to see if copyright can subsist without a focus on labor. And in considering this test, it must be seen from the perspective of a minimal degree of creativity, wherein creativity doesn't extend to novelty or inventive thought. In its explanation, the court says arrangement of facts or data or the case law is already included in the judgment of the court. Therefore, creativity of SEC would only be addition of certain facts or material already published, case law published in another law report, and its own arrangement and presentation of the judgment of the court in its own style to make it more user-friendly. This selection arrangement can be viewed as typical and at best result of the labor skill and investment of capital lacking even minimal creativity. It does not as a whole display sufficient originality so as to amount to an original work of the author. To support copyright, there must be some substantive variation and not merely a trivial variation. Not the variation of the type where limited ways or unique ways of expression available and an author selects one of them which can be said to be a garden variety. What we are then understanding is that certain types of modification, even though they require effort and perhaps also some skill, but without the consideration of judgment and the consideration whether there is a minimal level of creativity, it would be not considered to be an original work. In comparison, let us look at some other elements of expression brought in by SEC which were considered as creative by the Indian Supreme Court. As you can see, the court is suggesting that inputs which were made in the original text. What are these inputs? 1. Segregating existing paragraphs in the original text by breaking them into separate paragraphs. Adding internal paragraph numbering within a judgment after providing uniform paragraph numbering. And indicating in the judgment the judges who have dissented or concurred by introducing the phrases like concurring, partly dissenting, etc. You can see here that the kind of inputs that the court is considering as creative as against basic arrangements is that there is a certain level of skill and a certain judgment of its application which would be needed to undertake these kinds of activities. For instance, without having read the judgment, without having understood its individual components, would it not do a big disservice to the users if paragraphs were split unevenly? Would it not be a disservice to users and, in fact, a great disservice to the court itself if the concurring portion of the judgment and dissenting portion is in fact marked incorrectly? And therefore, according to the court, the use of skill and the manner of its usage can in fact satisfy creativity. Therefore, according to the court, how do we determine skill and judgment? The skill here, according to the court, can be understood as the editor who inserts para numbering must know how legal argumentation and legal discourse is conducted and how a judgment of a court of law must read. And judgment, often legal arguments or conclusions, are either clubbed into one paragraph in the original judgment, or parts of the same argument are given in separate paragraphs. It requires judgment and the capacity of discernment for determining whether to carve out a separate paragraph from an existing paragraph in the original judgment or to club together separate paragraphs in the original judgment of the court. I'm sure now you are able to clearly understand how certain types of expressions can clearly fit within the requirement of minimal degree of creativity and certain other types of expression would not. Therefore, according to the court, these inputs specifically, which as you can see is an exercise of brain work, which is not just a mechanical process, satisfies the flavor of minimal amount of creativity. You can see this in terms of the basic arrangements which were done in copy editing. The court had used the expression does not give the flavor of minimal requirement of creativity. What we then understand if we are to look at these three judgments: Feist versus Rural of the US Supreme Court, CCH Canadian of the Canadian Supreme Court, and Eastern Book Company versus DB Modak, the Indian Supreme Court. These judgments have a uniformity among their constructions, and the Indian Supreme Court draws from the evolution of originality from mere application of doctrine of Svedabra to the application of minimal degree of creativity. Hopefully, now originality as a foundational consideration is very clear to all of us. In the next week, we are going to be discussing some very important subject matters which are not considered as satisfying originality in order for copyright to subsist in them, which are sound recordings and cinematograph films. And we will also be discussing a very important facilitator of copyright application, copyright societies. Thank you for joining me. See you all in the next session. Thank you.